Joining us next to analyze the legality of the most recent arraignment against former President Trump, we have Mike Davis, founder and president of the Article 3 Project. Mike Davis, thank you so much for joining us.
Thank you for having me.
Of course, Mike, with regard to the Espionage Act, before 1978, former presidents, from what I understand, owned all documents from their presidencies, including all national defense information. There's never been any suggestion that their holding on to such documents violated the Espionage Act. How might this apply to this case?
That's the problem with this case. That is the legal issue that is the reason this indictment is legally flawed as a matter of law, because former presidents are allowed to have their presidential records when they leave office, whether they are classified or not, and that is in the Presidential Records Act. And that's why Congress gives former presidents secure office space, federally funded staff, and Secret Service protection in the heavily guarded office of the former president. And the Biden Justice Department, Merrick, Garland, and Jack Smith are ignoring the Presidential Records Act, which controls a president's handling of his presidential records, classified or not, and they are simply charging President Trump for retaining national defense information, essentially classified is what they're arguing, information under the Espionage Act. The problem is that he's allowed to retain his presidential records, and so they can't charge espionage for something a former president is allowed to have under the Presidential Records Act.
Mike, we have some sound, excuse me, from former President Trump. This was after the arraignment yesterday where he gave a speech at Bedminster. Let's play that sound and get your reaction on the other side.
The president enjoys unconstrained authority to make decisions regarding the disposal of documents. That's unconstrained to make that decision. Neither the archivist nor Congress has the authority to veto the president's decision.
Does this support what you just said?
That's absolutely correct. The Biden Justice Department, Merrick Garland, Jack Smith, they are ignoring key legal precedent here. They are ignoring the Presidential Records Act, which we just discussed. The Presidential Records Act says that any document created or received by the president or his White House staff are presidential records. He's allowed to have his presidential records when he leaves office. They belong to the government, but the former president can have them anytime he wants. There's also a distinction with this Clinton sock drawer case from 2012. An Obama judge ruled that it's the outgoing president's sole determination whether records are presidential records that go to the government and he can access them anytime he wants, or they're personal records that belong to him, which is what presidential records were before the Presidential Records Act, before Nixon won a legal battle over his presidential records and Congress changed the law. In 2012, this Obama judge held that President Clinton could have 8 years of highly classified audio recordings of his presidency, including discussions with foreign leaders, obviously highly classified, in his sock drawer. There was no raid. There was no indictment. This is something that is resolved through negotiations and civil lawsuit, not home raids and indictments. And this is a bogus political hit by Biden to go after Trump because they fear he's going to win the next election.
Mike, assuming this goes to trial without being dismissed, much of the indictment rests on the allegation that Trump kept national defense documents willfully with criminal intent. Do you think, with that said, the prosecutors will have trouble convincing a jury of willful criminal intent?
Yeah, because they're not alleging that Trump did anything to harm the national security of our country. They're not saying that he was using classified documents to secure millions corruptly like Hillary Clinton did when she was using classified documents for her Clinton Foundation pay-for-play bribery schemes, or when then Vice President Joe Biden used classified information to corruptly secure millions from China and Ukraine. There's no allegation here that Trump tried to use his records that he's allowed to have under the Presidential Records Act. Hillary and Biden were not allowed to have stolen classified records, but President Biden was allowed to have his presidential records. There's no evidence whatsoever he tried to harm America with them, and he's allowed to have them under the Presidential Records Act. So how could you charge a president for retaining his presidential records under the Espionage Act and try to throw him in jail for the rest of his life. Joe Biden wants his presidential opponent to be jailed and die in prison instead of Joe Biden facing Donald Trump in 2024.
Mike Davis, Article 3 Project. Thank you so much.
Thank you.